Constitution of India, Part 6, Chapter 5, The High Courts in the States, Article 214 to 232. Article 214, High Courts for States. There shall be a High Court for each state. Article 215, High Courts to be courts of record. Every High Court shall be a court of record and shall have all the powers of such a court, including the power to punish for contempt of itself. Article 216, Constitution of High Courts. Every High Court shall consist of a Chief Justice and such other judges as the President may from time to time deem it necessary to appoint. Article 217, Appointment and conditions of the office of a judge of a High Court. Every judge of a High Court shall be appointed by the President by warrant under his hand and seal on the recommendation of the National Judicial Appointments Commission, referred to in Article 124A, and the Governor of the state, and in the case of appointment of a judge other than the Chief Justice, the Chief Justice of the High Court shall hold office, in the case of an additional or acting judge as provided in Article 224, and in any other case until he attains the age of 62 years, provided that a judge may, by writing under his hand and addressed to the President, resign his office. A judge may be removed from his office by the President in the manner provided in Clause 4 of Article 124 for the removal of a judge of the Supreme Court. The office of a judge shall be vacated by his being appointed by the President to be a judge of the Supreme Court, or by his being transferred by the President to any other High Court within the territory of India. A person shall not be qualified for appointment as a judge of a High Court unless he is a citizen of India and has for at least 10 years held a judicial office in the territory of India, or has for at least 10 years been an advocate of a High Court, or two or more such courts in succession. Explanation. For the purpose of this clause, in computing the period during which a person has held a judicial office in the territory of India, there shall be included any period after he has held any judicial office during which the person has been an advocate of a High Court, or has held the office of a member of a tribunal, or any post under the union or a state requiring special knowledge of law. In computing the period during which a person has been an advocate of a High Court, there shall be included any period during which the person has held judicial office or the office of a member of a tribunal or any post under the union or a state requiring special knowledge of law after he became an advocate. In computing the period during which a person has held a judicial office in the territory of India or been an advocate of a High Court, there shall be included any period before the commencement of this Constitution during which he has held a judicial office in any area which was comprised before the 15th day of August 1947 within India as defined by the Government of India Act 1935, or has been an advocate of any High Court in any such area as the case may be. If any question arises as to the age of judge of a High Court, the question shall be decided by the President after consultation with the Chief Justice of India, and the decision of the President shall be final. Article 218. Application of certain provisions relating to Supreme Court to High Courts. The provisions of Clause 4 and 5 of Article 124 shall apply in relation to a High Court as they apply in relation to the Supreme Court, with the substitution of reference to High Court for references to the Supreme Court. Article 219. Oath or affirmation by judges of High Courts. Every person appointed to be a judge of a High Court shall, before he enters upon his office, make and subscribe before the Governor of the state or some person appointed in that behalf by him an oath or affirmation according to the form set out for the purpose in the third schedule. Article 220. Restriction on practice after being a permanent judge. No person who, after the commencement of this Constitution, has held office as a permanent judge of a High Court shall plead or act in any court or before any authority in India except the Supreme Court and the other high courts. Explanation. In this article, the expression High Court does not include a High Court for a state specified in Part B of the first schedule, as it existed before the commencement of this Constitution, the 7th Amendment Act 1956. Article 221. Salaries etc. of judges. They shall be paid to the judges of each High Court such salaries as may be determined by Parliament by law, and until provision in that behalf is so made, such salaries as specified in the second schedule. Every judge shall be entitled to such allowances and to such rights in respect of leave of absence and pension as may from time to time be determined by or under law made by Parliament, and until so determined, to such allowances and rights as are specified in the second schedule, provided that neither the allowances of a judge nor his rights in respect to leave of absence or pension shall be varied to his disadvantage after his appointment. Article 222. Transfer of a judge from one high court to another. The President may, on the recommendation of the National Judicial Appointments Commission, referred to in Article 124A, transfer a judge from one high court to any other high court. When a judge has been or is so transferred, he shall, during the period he serves after the commencement of this Constitution, 15th Amendment Act 1963, as a judge of the High Court, be entitled to receive, in addition to his salary, such compensatory allowance as may be determined by the Parliament by law, and until so determined, such compensatory allowance as the President may by order fix. Article 223. Appointment of Acting Chief Justice. When the office of Chief Justice of a High Court is vacant, or when any such Chief Justice is, by reason of absence or otherwise, unable to perform the duties of his office, the duties of the office shall be performed by such one of the other judge of the court as the President may appoint for the purpose. Article 224. Appointment of additional and acting judges. If by reason of any temporary increase in the business of a High Court, or by reason of arrears of work therein, it appears to the President that the number of the judges of that court should be for the time being increased, the President may, in consultation with the National Judicial Appointments Commission, appoint duly qualified persons to be additional judges of the court for such period, not exceeding 2 years, as he may specify. When any judge of a High Court, other than the Chief Justice, is by reason of absence or for any other reason unable to perform the duties of his office, or is appointed to act temporarily as the Chief Justice, the President may, in consultation with the National Judicial Appointment Commission, appoint a duly qualified person to act as the judge of that court until the permanent judge has resumed his duties. No person appointed as an additional or acting judge of the High Court shall hold office after attaining the age of 62 years. Article 224A. Appointment of retired judges at sitting of High Court. Notwithstanding anything in this chapter, the National Judicial Appointments Commission, on a reference made to it by the Chief Justice of the High Court of any state, may, with the previous consent of the President, request any person who has held the office of the judge of that court or of any other High Court to sit and act as a judge of the High Court for that state, and every such person so requested shall, while so sitting and acting, be entitled to such allowances as the President may, by order, determine and have all the jurisdiction, powers and privileges of, but shall not otherwise be deemed to be a judge of that High Court, provided that nothing in this article shall be deemed to require any such person as aforesaid to sit and act as a judge of that High Court, unless he consents to do so. Article 225. Jurisdiction of existing High Courts. Subject to the provisions of this Constitution and to the provisions of any law of the appropriate legislature made by virtue of powers conferred on that legislature by this Constitution, the jurisdiction of and the law administered in any existing High Court and the respecting powers of the judges thereof in relation to the administration of justice in the court, including any power to make rules of court and to regulate the sittings of the court and of members thereof sitting alone or in division court, shall be the same as immediately before the commencement of this constitution, provided that any restriction to which the existence of original jurisdiction by any of the high courts with respect to any matter concerning the revenue or concerning any act ordered to or done in collection thereof was subject immediately before the commencement of this constitution shall no longer apply to the exercise of such jurisdiction. Article 226. Power of high courts to issue certain writs. Notwithstanding anything in Article 32, every high court shall have power throughout the territories in relation to which it exercises jurisdiction to issue to any person or authority, including in appropriate cases any government in whose territories directions, orders or writs, including writs in the nature of habeas corpus, mandamus, prohibition, quo warranto and certiorari, or any of them for the enforcement of any of the rights conferred by Part 3 and for any other purpose. The power conferred by Clause 1 to issue directions, orders or writs to any government, authority or person may also be exercised by any high court exercising jurisdiction in relation to the territories within which the cause of action, wholly or in part, arises for the exercise of such power, notwithstanding that the seat of such government or authority or the residence of such person is not within those territories. Where any party against whom an interim order, whether by way of injunction or stay or in any other manner, is made on, or in any proceedings relating to a petition under Clause 1 without furnishing to such party copies of such petition and all documents in support of the plea for such interim order, and giving such party an opportunity of being heard, makes an application to the High Court for the vacation of such order and furnishes a copy of such application to the party in whose favor such order has been made, or the counsel of such party, the High Court shall dispose of the application within a period of 2 weeks from the date on which it is received, or from the date on which the copy of such application is so furnished, whichever is later, or where the High Court is closed on that day of that period, before the expiry of the next day afterwards on which the High Court is open, and if the application is not so disposed of, the interim order shall, on the expiry of that period, or as the case may be, the expiry of the next day, stand vacated. The power conferred on a High Court by this article shall not be in derogation of the power conferred on the Supreme Court by Clause 2 of Article 32. Article 227. Power of superintendence over all courts by the High Court. Every High Court shall have superintendence over all courts and tribunals throughout the territories in relation to which it exercises jurisdiction. Without prejudice to the generality of the foregoing provision, the High Court may call for returns from such courts, make and issue general rules and prescribe forms for regulating the practice and proceedings of such courts, and prescribe forms in which books, entries and accounts shall be kept by the officers of any such courts. The High Court may also settle tables of fees to be allowed to the sheriff and all clerks and officers of such courts, and to attorneys, advocates and pleaders practicing therein, provided that any rules made, forms prescribed or tables settled under Clause 2 or Clause 3 shall not be inconsistent with the provision of any law for the time being in force, and shall require the previous approval of the governor. Nothing in this article shall be deemed to confer on a High Court powers of superintendence over any court or tribunal constituted by or under any law relating to the armed forces. Article 228. Transfer of certain cases to High Court. If the High Court is satisfied that a case is pending in a court subordinate to it involves a substantial question of law as to the interpretation of this Constitution, the determination of which is necessary for the disposal of the case, it shall withdraw the case and may either dispose of the case itself or determine the said question of law and return the case to the court from which the case has been so withdrawn, together with a copy of its judgment on such question, and the said court shall on receipt thereof proceed to dispose of the case in conformity with such judgment. Article 229. Officers and servants and the expenses of high courts. Appointments of officers and servants of a high court shall be made by the Chief Justice of the court or such other judge or officer of the court as he may direct, provided that the governor of the state may by rule requires that in such cases as may be specified in the rule, no person not already attached to the court shall be appointed to any office connected with the court, save after consultation with the State Public Service Commission. Subject to the provisions of any law made by the legislature of the state, the conditions or services of officers, the servants of a high court shall be such as may be prescribed by rules made by the Chief Justice of the court or by some other judge or officer of the court authorized by the Chief Justice to make rules for the purpose, provided that the rules made under this clause shall, so far as they relate to salaries, allowances, leave, or pensions, require the approval of the governor of the state. The administrative expenses of a high court, including all salaries, allowances, and pensions payable to or in respect of the officers and servants of the court, shall be charged upon the consolidated fund of the state, and any fees or other monies taken by the court shall form part of that fund. Article 230. Extension of jurisdiction of high courts to union territories. Parliament may by law extend the jurisdiction of a high court to or exclude the jurisdiction of a high court from any union territory, where the high court of a state exercises jurisdiction in relation to a union territory. Nothing in this constitution shall be construed as empowering the legislature of the state to increase, restrict, or abolish that jurisdiction. And the reference in Article 227 to the governor shall in relation to any rules, forms, or tables of subordinate courts in that territory be construed as a reference to the President. Article 231. Establishment of a common high court for two or more states. Notwithstanding anything contained in the preceding provisions of this chapter, Parliament may by law establish a common high court for two or more states, or for two or more states and a union territory. In relation to such high court, the reference in Article 227 to the governor shall in relation to any rules, forms, or tables for subordinate courts be construed as a reference to the governor of the state in which the subordinate court are situated, and the references in Article 219 and 229 to the state shall be construed as a reference to the state in which the High Court has its principal seat, provided that such principal seat is in a union territory. The references in Article 219 and 229 to the Governor, Public Service Commission, Legislature, and Consolidated Fund of the state shall be construed respectively as references to the President, Union Public Service Commission, Parliament, and Consolidated Fund of India. Article 232. Interpretation. Article 230, 231, and 232 substituted by Article 230 and 231 by the Constitution, the 7th Amendment Act 1956.